Hello, I'm Christina Jimenez with the Jimenez Law Firm.
And I'm Josh Floyd with Jimenez Law Firm as well.
And today we are going to talk to you about certain things that you need to make sure that you do not do in a child custody case, because if you do them, then you can potentially upset the judge. So the first thing that we want to talk to you about is this concept of co-parenting. And this may be something that you all have heard about in the past. And essentially all it means is that you guys have to learn to work with one another. And so, Floyd, we've had this come up in a couple of our cases where somebody is potentially hiding the kids. What are your thoughts on that?
A lot of times whenever we see one parent take off with a child and hide the child from the other parent, generally that parent will lose custody. Courts don't like it whenever you take a child and abscond with the child. Certainly it's terrible co-parenting, but when you abscond with a child, courts don't like it.
Well, and so I think that, one of the things that we have to remember if we find ourselves in a situation, or you find yourself in a situation where you feel like you're in danger or the child's in danger and you have to potentially hide the child for your safety or the safety of the child, you have to make sure that you're doing it in a proper manner. And that would include, hiring a lawyer or figuring out how to file documents with the court on your own, because if you do that, then the court has remedies in place for you to be able to protect yourself and your child legally. It's whenever you decide you're going to take the law into your own hands and potentially flee to another state or to go to an unknown place and fail to disclose it, that's when the courts get fairly frustrated because there's no adequate remedy for the other parent. Now, the other thing that we see a lot of is this concept of disparaging remarks. And so, Floyd, what are your thoughts on that?
Before we go on to disparaging remarks, I want to touch again on the absconding with the child, because it is one thing to take off with a child if you're in fear for yourself or for the child and you don't take the proper legal remedies. Obviously, it's best to take the legal remedies, but if not, it's one thing to do that out of fear of safety, but it's a completely different thing to do it to use the child as a pawn or to gain a strategic advantage. That's where we see it hit the judges the most, right? If you're using the child as a pawn, you guys are separating, you take off with a child just to hurt the other parent, that's when the judge is going to be very angry with you.
Well, and to kind of piggyback on that too, Floyd, the other thing is that if you are if you have absconded, or if you're thinking of taking off with a child and you feel in your own mind that it's justified that this kiddo's or that you need to protect yourself, you better make damn sure that you have some sort of evidence to back that up, because that is not something that these courts are going to take lightly. So best advice is do not do it. If there's some issues going on, you need to call the police, you need to call an attorney, you need to try to bring this to the attention of the court before you take that matter into your own hands. So now going to disparaging remarks.
So disparaging remarks is basically talking badly about the other parent in front of the child or the children. Also terrible co-parenting, because you want the parent to look up to the other parent, right? Even if you don't like them, you guys once loved each other, you once thought you were good people, or the other person was a good person, but you don't want to hurt the child. All you do whenever you're talking badly about about the child's mother or father, right, is hurting the child, not the other person. And so courts take that very seriously as well.
And so one of the things that I've heard, several judges say is, your child is 50% you and 50% the other parent. And so whenever you're talking poorly about that other parent, you're essentially talking poorly about your child, because they are an extension of that parent. So just don't do it, because if in fact there's evidence that's produced to that effect, there's going to be some judges that are going to be pretty upset with you. The next topic with regard to co-parenting is talking about litigation. a lot of courts, whenever you file a petition for divorce or any sort of custody dispute, they have what we call injunctions in place. And basically those are rules that say don't do certain things. And most of them say don't disparage. A lot of them say don't discuss litigation in the presence of the children. And that's always a difficult kind of concept for some of our parents to understand because, you know, especially when you get into preteens or teens, they kind of have an idea of what's going on. And so it's always kind of interesting to guide them in how to respond to certain questions. And so, Floyd, what do you normally tell your clients?
I tell them let the kids be the kids, right? Let the adults deal with the adult stuff. Let the kids deal with the kids stuff. When they are preteens and stuff like that, they will ask questions. I tell them, you know, just tell them, don't worry about it. Mommy, daddy love you. We're going to handle it. We're going to look out for you, and it's all going to be okay in the end. You do your thing, and we'll worry about all this. So,
very good. So some of the obvious issues that come up that we have to deal with, and things that obviously are going to negatively impact your custody case, is if you're arrested for family violence, or if there are accusations that you've committed an act of family violence. And so obviously best advice is to not do those things, right? To not find yourself in those situations. But if you commit an act of family violence against your spouse or the other parent or the child, you're going to have some serious consequences whenever we walk into a courtroom. And so there's, Floyd, why don't you talk to them about the presumption if there's a finding of family violence?
So with the finding of family violence, the presumption is that you guys should not be appointed as joint managing conservators, which means one person basically has all the rights to make decisions, and the person that committed the family violence doesn't have those rights. And then along with that goes protective orders, and if a protective order is granted, the presumption of supervised visits. It's just not a good situation to find yourself in.
Now, finally, any sort of allegations or, I guess, proof that you have substance abuse problems with illegal drugs or alcohol. So one thing that a lot of courts do, and a lot of people don't know about, but the courts do have the ability to drug test you. Most often they're going to order that you go and do 180-day hair follicle test. And if that comes back positive for an illegal substance, then you could find yourself getting some sort of restricted access or supervised access. And so, you know, we have to be very careful about doing those things when you have young children, and you could potentially find yourself in a custody dispute. So Floyd, why don't you talk a little bit about marijuana use, because we know that it's legal in some states and it's obviously not legal in Texas, and kind of the impact that that can have on a custody dispute.
Yeah, so I was going to say that the judges throughout Texas vary as much as the states do on how they feel about marijuana. I mean, you've got some judges that take it lightly, and then you've got some that they don't care if it's marijuana or heroin. You're getting supervised visits if you test positive. But for the most part, because the courts can't distinguish whether you used it in Texas illegally or whether you used it in Colorado where it was legal, they're going to take it as though you used it in Texas. And that's the presumption they're going to go with, because you got to remember the judge's job is to protect the child, right? And so rather than take that risk that the child is going to be around somebody that is using drugs illegally, they're going to presume that you did and protect that child.
Very good. Now, one of the questions that oftentimes we have during a case or whenever we're doing a consultation is, you know, how do I prove that these things have actually occurred? So obviously, anytime you find yourself in a custody dispute, there is a possibility that you go to court, right? Essentially what happens is your lawyer's going to call you as a witness, and potentially the other side's lawyer's going to call them as a witness, and then we go in and we present evidence to try to convince the court that they should rule in our favor, right? And so when we're dealing with these types of issues with regard to, you know, disparaging remarks, talking about the case, family violence, things like that, we have various tools that we use. One of them is recordings. So Floyd, what are your thoughts on recordings?
Well, there's several types of recordings. That's kind of a big question, but I mean, we have parties that record other people's phone calls. We have recording exchanging of visitations. I had one, I think it was last week, where someone had pulled the video camera from a home and used that. So there's all kinds of recordings, and they're good as long as somebody knows how to use the device that they're recording on, and it's credible. It's going to come in, and with technology nowadays, it's very hard to hide the stuff that you would normally be able to get away with.
So talk to me about, like if you're on a phone call with someone else, is that legal? Are you able to do that?
Yes, in the state of Texas, you are allowed to record a conversation that you are a party of without the other people knowing. So that doesn't mean like if you pick up the phone and hand the phone to your child to talk to mom, you can't record that conversation because you're not a part of that conversation. But if I were recording you right now, that would be perfectly legal and admissible in court.
Very good. Now, obviously, next is photos, right? And so any photos that you can fairly and accurately depict what they purport to depict. Basically, that just means it is what it says it is, right? Well, it is what you say that.
We're not redoing this video, so we're going
to. You have to redo it.
So as long as it is what it purports to be, right? So it's photograph.
It is what it is. That's that's the saying. And it is going to be admissible in court. Okay. And so the next obvious tool that we're going to use is calling witnesses. And so any third parties that you have that can come in and testify that a certain event has occurred, or, you know, perhaps that the other party had a history or pattern of, you know, alcohol abuse and would become angry or aggressive after they used alcohol, or perhaps they, you know, abused an illegal substance and placed this child in danger and they personally witnessed with their own two eyes that specific incident. Those are the types of things that are going to be very, you know, compelling to a court. Obviously, the less attached that they are to you. And what I mean by that is, you know, if it's your mom or your dad or your sister coming in and testifying, a lot of times, you know, these people may not be the most credible because the court knows that they love you and that they're going to testify, you know, for you. But if we have independent third parties like teachers and counselors and coaches, those are the witnesses that I really like to call because they don't have a dog in the fight. And then
my favorite witnesses are baby mama number 1 to testify in your baby mama number 2 hearing, or the opposing party's family. Those are always fun.
And then finally, you know, we have this opportunity for the court to confer with the child subject of this suit, right? So basically, the code says that any child 12 years of age or older, the court shall confer with them with regard to who they want to live with, okay? If they're less than 12 years of age, then the court it's within their discretion, okay? And so basically, you know, I guess the youngest child that I've ever, that a judge has ever wanted to visit with was maybe like 6 or 7. And those were pretty extenuating circumstances. Courts typically don't like to do that. Floyd, what are your thoughts? What have you seen?
I think the majority of courts don't like to talk to kids anyway. They do because the code requires them to. Code doesn't require them to follow what the kid wants. It just requires them to talk to them. Yeah, so.
Well, and I've seen it happen where, you know, you have mom come in and she's making allegations that dad was, you know, a drunk and a violent drunk at that. And then you have dad come in and dad says, never happened, I don't drink. And somehow or another it comes up, or one of the parents mentions, well, this 13-year-old child or 12-year-old child, 10-year-old child was there, right? And so on occasion, the court will kind of talk to the child just to figure out who is in fact being truthful and who's not. Keep in mind, most of these judges are not going to interrogate these kids and say, well, your mom said this and your dad says this. What they do is they just talk to them and they try to get some sort of an inclination as to who is in fact being more truthful, and is there anything that this kid has identified or recognized that is in fact dangerous to him, and do I need to potentially do something to protect him?
And if you plan on having your child talk to the judge, the worst thing you can do is tell the child what to say. Judges can figure that out quick, and I promise you that you're not going to like whatever the judge says if the judge finds out you've been telling the child what to say to them.
And so I think the overall theme, and what I really encourage our clients to do, is to really keep the kids out of it. You know, they're just, your custody case is none of their business, and we have to try to shelter them as much as we possibly can, and try to keep them as safe and protected from all of this nonsense of the custody dispute, because ultimately that's what is most important, and that is also what is going to be potentially helpful to your child custody case. If you're one of those parents that's putting your kid right in the middle of this, you're going to have a very, very difficult time with Texas judges. Do you agree with that, Floyd?
I agree 100%.
Very good. Well, we hope that this helps you guys. As always, if you need any help, you guys need to reach out to a well-educated and experienced family law attorney.